Good afternoon, everyone. I, Chaitra Kumari, Assistant Professor, Vaikunta Baliga College of Law, deem it as my privilege to welcome each one of you to today's informative session. Respected resource person, esteemed faculty members, all the participants, and dear students. Good afternoon, everyone. I, Chaitra Kumari, Assistant Professor, Vaikunta Baliga. I cordially welcome all of you to the certificate course in research and academic writing organized by Karnataka Institute of Law and Parliamentary Reforms, KILPAR, Bengaluru, in association with Vaikunta Baliga College of Law, Udupi. Today marks the beginning of an enriching journey where we will enhance our research skills and academic writing expertise. I invite you to engage actively with our renowned resource person. Please join me in welcoming a warm welcome to today's resource person, Professor Dr. Ishwar Bhatt sir, former Vice Chancellor of Karnataka State Law University and former Vice Chancellor of West Bengal National University of Judicial Sciences, Kolkata. Welcome you, sir. I would like to extend a hearty welcome to Dr. Nirmala Kumari K, Director, Vaikunta Baliga College of Law, Udupi. Welcome you, ma'am. I also welcome Dr. Raghunath K.S., Principal, Vaikunta Baliga College of Law, Udupi. Welcome you, sir. I also welcome all the participants, faculty members, and all the students of BBCL. Welcome you all. Now, I would like to take this opportunity to introduce Professor Dr. P. Ishwar Bhatt sir to the gathering. Sir was born in 1955 at Padnur village, Puttur Taluk, Karnataka, to an agricultural family. He had his early education in Padnur and Puttur, studied at Vivekananda College, Puttur, and completed his law degree at Udupi Law College. Sir further attained his LLM degree from the University of Mysore with a gold medal and also obtained MA degree in history. He got his PhD degree in law from the University of Mysore for the thesis on interrelationship among fundamental rights in the year 1994 and LLB from National Law School of Bengaluru for the thesis on non-profit voluntary organizations law. Dr. Ishwar Bhatt sir has 40 years of teaching experience and has taught in various institutions. Served as Professor and Dean of Faculty of Law, University of Mysore. Acting Vice Chancellor of University of Mysore for 4 months and as Vice Chancellor of West Bengal National University of Judicial Sciences, Kolkata from 2011 to 2018. Sir has specialized in constitutional law, administrative law, law and social transformation, non-profit law, legal research methodology, intellectual property rights, and water law. Sir also served as a member of syndicate and academic council for several universities. He was a Fulbright Nehru Visiting Fellow and involved in co-teaching NPO law in Columbus Law School, Catholic University of America in the year 2010. Dr. P. Ishwar Bhatt served as a proud recipient of Shastri Research Faculty Awardee in 1992 for researching at York, Toronto, and Ottawa universities on language rights. Sir has participated and presented papers in more than 100 national and international seminars. Furthermore, he has authored books on non-profit voluntary organizations law, law and social transformation, fundamental rights and administrative liability, and published 115 research articles in national and international journals and books. His book entitled Idea and Methods of Legal Research and Harmful Superstitions and Legal Responses are under print. Sir is an inspiration to all of us. May his presence bring forth wisdom and knowledge in abundance. So with this word, I introduce Sir Professor Dr. Ishwar Bhatt Sir to the audience. Welcome you, sir. Without much delay, I request Dr. Ishwar Bhatt Sir to share his expertise on the topic research ethics. Over to you, sir.
Sir, unmute you. Sir, you have to unmute your device, sir.
Director of Legal Studies, Vaikunta Baliga Law College, Dr. Nirmala Kumari, Principal Sri Raghunath, all the students and participants in this workshop. The topic of today's discussion is ethics in legal research. You are aware that research intends to generate new knowledge. Knowledge has links with welfare, justice, and truth, and also self-perfection. This when the objective of research has links with the welfare of the people at large. It is essential that the method of getting truth through research should also be associated with certain ethical or moral principles, ethical norms or moral considerations, or to govern various levels and spheres of research activity. Thus, from the moment of selection of research topic, data collection, analysis, and say conducting research through observation study or interview, questionnaire, or analysis or various other means. It is essential that the researcher should ensure compliance with the ethical principles or moral principles. There is an obligation on the part of the individual researcher, the research institution, higher education institutions, and universities to ensure that ethical principles or moral considerations are duly complied with. The researcher has a responsibility towards the society at large because it is for the benefit of the society that he conducts research, and he has that moral duty to uphold some ethical principles in the course of research. There's four important principles of ethics or moral considerations shall operate in the course of research. The first principle is that there shall not be malevolence to anybody. In other words, research shall not result in any harm to any of the participants or to the society at large. Thus, the persons or the communities upon whom the researcher conducts research shall not be put into any kind of difficulties, exploitations, moral or emotional pressures, or any other type of human right violations. That is the first principle, non-malevolence. The second principle is the principle of benevolence. Through research, there shall be promotion of welfare of the society at large. See, not only getting a truth, but also disclosing that truth with adequate evidence in support of all those truthful findings, and inform the society about the way in which the problems faced by the society could be resolved. This is the second principle. Perhaps the evolution of the second principle is traceable to the 20th century development, where uh, in America, Tuskegee syphilis incident took place. As many as 400 black people belonging to backward section of the society in America were subjected to certain types of medical test, medical treatment. There is a without using penicillin or other medicines. They were subjected to observation. Of course, they were suffering from a venereal disease, and instead of providing the best medicine possible for curing them, they were allowed the traditional method of curing, whether the traditional method of curing syphilis is appropriate. What are the problems faced by the communities because of the venereal disease? About all those things, research was conducted for several decades, and all those persons who are treated as a laboratory objectives or guinea pigs, like guinea pigs, they suffered a lot. Moral suffering, suffering in health, suffering because of poverty, suffering because of lack of access to welfare facilities. All these things put them into very awkward situation. It is only Congress which could enact legislation subsequently to provide certain compensation remedies or some other thing. And how research ought not to result in any harm to the society, about that some awareness was brought. See, in India also, there was an experience about uh, the uh, experience of a particular community. There's a persons who are engaged in the profession of prostitution. What is their uh, problem, social problem, health problem, economic problem? About that, a study was conducted, but there was a disclosure of the identity of the members of that community, and that resulted in a wholesale shunning of the people belonging to that region, and it caused some emotional stress upon those members. See how through research activity, I mean, conducting of research activity, like say conducting a observation study, or of uh, say questionnaires, all these things had the consequence of giving undue publicity to particular community. This was harming the interests of those people. There was a human right violation. See, persons who were affected by syphilis, they were guilt. I mean, they were victims of human right violation. Similarly, the people in India, there's a the community of prostitutes in Uttarakhand who suffered a lot because of this unsafe type of research, became victims of human right violation. That's why there is a this second principle that there there shall be promotion of welfare. First, there shall be protection of the participants as well as interests of the society. Secondly, there shall be benefit to the society. The third principle is that there shall be autonomy on the part of participants as well as other people who are engaged in research. The fourth principle is that there shall be principle of justice. That's the outcome of research shall be shared by the society as a whole. In other words, people as a whole should have access to the knowledge emerging through research. See, in United States and in Europe, during I mean after the Second World War, when research was conducted, how some of the ethical principles were to be followed by all the uh, researchers and research institutions. About that, much emphasis was given. In India, ethical guidelines were given by a particular body called a National Committee for Ethics in a Social Science Research in Health, and that body issued a detailed guidelines, ethical guidelines for social science research and health. When pertaining to health or pertaining to any of the issues relating to social science, research is conducted. It is the responsibility of the researcher to abide by the ethical principles. Insofar as medical research is concerned, under the chairmanship of Honorable Justice H.R. Khanna, in 1980, one committee was constituted by Indian Council for Medical Research, ICMR, and that committee laid down number of guidelines about the way in which medical research is to be conducted. The interests of the participants in a research, or objects, or the persons upon whom research is to be conducted, their safeguard, their human right protection, and their welfare shall be ensured by the researcher. This committee made a number of recommendations. Ethical committee was subsequently chaired by Honorable Justice M.N. Venkatachalaya, and that committee also laid down number of guidelines. See, relating to research in medical science, research in social science, research in relation to health, there are certain well-established ethical principles. Insofar as the law is concerned, there is no code as such, no ethical code governing legal research. But since the law is also one kind of a social science, and law is concerned with health interests also, whenever research is conducted in the field of law, which has a connection with the social science, or which has connection with the health, or law as one of the social science subjects, attracts application of this ethical guidelines for social science research in a yes, health. See, it is possible to draw inferences on the basis of the Constitution, on the basis of human rights principles, that there is an ethical obligation on the part of every legal researcher to protect the interests of the participants in the research, to maintain privacy, to ensure that the human right interests of the participants is not violated, and disclosure is made truthfully, and the uh, involvement of participants in the course of research is not based on exploitation, but based upon informed consent. The concept of informed consent becomes quite important. See, the participant who willingly agrees for subjecting himself to research should be informed about the purpose of research, the scope of that research, and the possible outcome of that research, and how social interest is going to be promoted through that research. About that, there ought to be adequate disclosure, and informed consent should be a free consent, and consent based on adequate knowledge, and there shall not be any kind of economic interest or such things. See, there shall be adequate consideration of all essential and relevant data, existing knowledge, and alternative views, so that the the outcome of a research shall be such that a perfect outcome is ensured through research. Suppose all the data is not analyzed. Suppose the data is partially analyzed, or some data is suppressed, then the research output will not be appropriate, and the researcher has an ethical responsibility to ensure that all the data, all the information are properly analyzed, and the inference is based on appropriate findings. Then researcher shall maximize the achievement of a public interest and social justice or social benefit. There is a promotion of a second principle. There is a benevolence to the society. Then a researcher shall have sincere commitment to the readiness to acquire knowledge. He must respect and protect autonomy and rights and dignity of persons. He shall ensure privacy, and he shall take adequate precautions so that risks shall be either minimized or risks shall be mitigated. See, so many types of research may involve certain harmful consequences. For example, the right to esteem on the part of the community of prostitutes was at stake when research was conducted in such a way that disclosure of identity of those persons took place in that instance, or when syphilis affected persons were kept away from medical treatment for decades together, and uh, of course, lack of access to penicillin and other life-saving drugs had put them into severe difficulties. Then, no unnecessary consumption of participants' time or resources shall take place. See, whether in the course of interview or in the course of say observation study or case study or uh, uh, distribution of questionnaire, etc. So there is the occurrence of undue delay. The time, precious time of the participants is taken away. Then it's going against the ethical principles. See, uh, of course, their time will have to be consumed, but there shall be minimization of such a consumption of time. Then all institutions associated with the research, or all persons associated with the research, or all universities or other bodies associated with the research shall see to it that the product of research is brought to the knowledge of people. That is why the research projects reports are submitted to the funding agencies. They're publicized in InflibNet, Shodh Ganga. Then the university takes all care to uh, bring the research work to the public domain by bringing it by uh, publishing in a website or publishing in Shodh Ganga, etc. In other words, there shall be dissemination of knowledge. See, uh, researcher has that ethical responsibility, as a he has a social responsibility of uh, uh, bringing knowledge of his research to the public, because he takes the advantage of time, opportunity, and resources in generating that knowledge, and he has that responsibility of disseminating knowledge with all people who are uh, interested in having access to such a knowledge. Another principle is that in the disclosure of such information or research output, there shall be adherence to the principle of honesty, uh, intellectual honesty, integrity, sincerity, and due acknowledgement of sources of such information. Suppose he suppresses such sources, it amounts to an act of plagiarism, and there are very stringent provisions under the law, especially the UGC guidelines, which have the force of law, so that actions may be taken against the individual who is responsible for such a act of plagiarism. Then he shall have total responsibility to the sponsors or funders or the agency which provides a fund. That's accounting about the money spent, then providing the research report to such an agency. All these are responsibilities of the researcher. This researcher has a right as well as a responsibility to ensure that through his research, no harm is taking place to others. In other words, welfare to the people will be possible. Then, of course, sharing of the benefit of knowledge with the people or with the society at large becomes a moral responsibility on the part of a researcher, so that the society will gain benefit, especially when relating to health or relating to social problems or relating to uh, severe economic problems. When valuable research findings are made by the researcher, it's quite appropriate that all such information shall be made available to the society. These are important responsibilities on the part of the researcher. Now, about some of the concepts, let me elaborate. See, I said that uh, the participants may participate only on the basis of informed consent. See, here uh, the role of participants becomes uh, significant, vital, because they are the source of information. See, when research is conducted about the behavior of ethnic community or their social customs or their family practices or their day-to-day activities. Suppose the researcher is a participant observer in that community and closely watches the activities, conduct, behavior of the members of that ethnic community. See, here he should disclose his identity. He should get the consent of the persons upon whom he is conducting research. He shall get the consent of that community in order to uh, get access to all such information. For that purpose, he has to disclose the purpose of research and how through that research some valuable finding may be made about the socio-economic problems of the ethnic communities, and possibly a better position may be attained in relation to all such social and economic problems. See, on that basis, when he gets consent, then it will be regarded as uh, getting such an opportunity on the basis of consent itself. Similarly, when uh, any specific person, say the uh, prisoners undergoing a death penalty upon whom research is to be conducted, it is only after obtaining their consent that research can be conducted. There's asking questions, having access to them, and getting information from them on the basis of interview. All these things could be done only on the basis of consent. They might be undergoing a lot of mental pressure, tension, and their emotional position shall not be subject to further deterioration by asking questions or by researching. Similarly, patients who are suffering from specific types of diseases and undergoing some treatment in hospitals. Suppose about them research is conducted, or research is conducted uh, about the medical procedure, or about the conduct of the doctors, or various other participants in that medical operation. See, here also, without their consent, if research is conducted, it is in violation of their right to privacy. They are entitled to keep their uh, keep their private interests intact, and there ought not to be intervention with the privacy of those persons, and informed consent becomes very much essential. Relating to each and every type of sociological research, when uh, research is conducted by associating with any persons or a community, getting their consent becomes a prerequisite. Otherwise, it will be in violation of uh, human right itself. Keeping confidentiality of information is another thing. See, at all levels of research, these ethical principles shall be followed. Is first, it shall be followed in the selection of the participants, then in getting information, the process of getting information, and in keeping the information intact and confidential. That is very much important. So was about the biological information or biographical information. Research is conducted about a very prominent person, say a former Chief Justice of India, is uh, the person upon whom research is conducted, about his childhood days, or about his correspondence with his friends, or say relatives, or other professionals, or about his uh, lectures, or various other private information. Of course, public lectures or judgments, or other printed information in the form of books might be accessed. There is no difficulty about that. But when it comes to their private, confidential communications, then it is essential that there ought to be kept confidentiality of such information, because otherwise there will be violation of right to privacy. Then what shall be the relation of the researcher vis-a-vis the society? See, vis-a-vis the society, he has that responsibility of uh, uh, honestly disclosing all such information. See, any kind of a fraud played upon the society by using wrong data, or by manipulation of data, or by misleading the audience, or the readers, or the society at large, all these are totally unethical. He may have some ulterior considerations, or biases, or prejudices. Out of such a prejudices, suppose he does these types of acts of playing a fraud upon the society, or by misleading, by providing erroneous information, or by giving a wrong analysis, then he does a great disservice to the society, and it is ethically improper. Then publication is a responsibility on the part of a researcher. See, there he should avoid sensational publication, which brings the society into, say, emotional outburst, dissatisfaction, or it conveys some hate message, etc. See, all these things shall be avoided, because the researcher, through his research, ought not to inflict any kind of adverse effect upon the society. Even if he is disclosing a truth, he should do it in an appropriate manner, and arousing the feelings of people, or appealing to their uh, emotions, or addressing through hate speech, or conveying some biases, etc., cannot be regarded as appropriate, and he should take care about all those things. His relation with the funders and sponsors. See, when funding is made by some funding agency, like say UGC, or ICSSR, or Ford Foundation, or some other funding agency, or some university, etc., it's a responsibility of the researcher to give uh, account statement in appropriate form, and uh, there ought not to be any kind of uh, corrupt practice, or any suppression, or any misleading information, because uh, as a researcher, he has to be honest even about financial integrity. Then what shall be the relation of a researcher with other researchers? Suppose research is conducted in a collective manner. A person is a principal investigator, and there are two or three junior researchers. See, there shall be mention of the contribution made by each of the junior researcher in the report as well as in a publication. There ought not to be exploitation of the junior researcher by the senior researcher, or by the institution, and uh, of course, any type of exploitation, like financial exploitation, moral exploitation, sexual exploitation, or other types of uh, extraordinary favors from junior researchers. All these things shall be eschewed by the researcher, because he is actually uh, pursuing the cause of truth, and pursuing the interest of knowledge, and as a representative of the intellectual world, he has that responsibility of promoting highest ethnic yes, highest ethical considerations, and he shall contribute towards such kind of ethical uh, conduct, best conduct on his part. See, another important ethical responsibility of the researcher is avoidance of plagiarism. See, plagiarism shall be avoided by developing one's own ideas. See, what is a plagiarism? Plagiarism is using someone's idea as his own idea, by representing that it is his idea, but it's actually an idea uh, expressed by some other person. Another person's idea, or another person's expression, is used by this researcher as his own. in order to glorify his contribution, or in order to uh, show that he is the innovator of a new idea, etc. Suppose he uh, projects that idea which is actually already prevalent, already published, and already in the name of some other person, then it is totally inappropriate. That is why plagiarism is something to be avoided. Intentionally, knowingly, and recklessly representing the words or ideas of another as one's own in any academic exercise, uh, or in any of the uh, publications. This is amounting to plagiarism according to uh, George Washington University policy relating to plagiarism. And UGC has laid down uh, elaborate set of guidelines. There is a University Grant Commission, promotion of academic integrity and prevention of plagiarism in a higher education institutions regulations 2018. This is not a guideline, this is a regulation itself. UGC regulation 2018 relating to uh, prevention of plagiarism in a higher education institutions. See, the features of these regulations can be briefly uh, explained, but it is essential that as researchers, you are expected to read this particular UGC regulation 2018. This is available in a official gazette, and it is available in internet. Of course, in any of the standard books on research also, there may be publication of this as an appendix. It is essential to go through all these uh, rules relating to prevention of plagiarism. See, as researchers, it is essential to know these rules meticulously and follow these rules and regulations carefully. 100% compliance with these rules and regulations is a must. That's why please go through all these regulations, and in your conduct, in your publications, and in your submission of for the projects, please ensure that these guidelines, these regulations are followed. As students will be submitting the term papers, it is expected that it should be product of your independent research, or as a students, or as a law graduates, you might be going for a publication of your article. That article should have been written by you, projecting your ideas, projecting some independent original views. It may be referring to the primary materials, it may be referring to the secondary materials, it may be referring to other academic works, but there ought to be honest acknowledgement of all the support that you have gathered from the field of knowledge. Because uh, any suppression on your part will give rise to an impression that these ideas, these words, and these beautiful sentences are your own. But the readers who come across other books or other publications which are used by you will detect you as the plagiarist, and your image as a researcher or a writer will be jeopardized. See, there'll be social condemnation. There'll be other penalties. Of course, UGC regulations impose so many penalties. If there is a violation of a plagiarism regulation, excessive similarity is involved in such a publication, then he will be disentitled to further submit his articles, or there will be derecognition of his degrees, or there will be disqualification that might be imposed on him. There are so many penalties which are mentioned there. Higher education institutions have the responsibility of bringing these regulations to the knowledge of the students. They shall train them. They shall provide adequate information about the regulations, so that perfect adherence to all these regulations will be possible, and total avoidance of plagiarism would also be possible by good knowledge of these rules which are preventing regulation. See, it is true that the information published elsewhere might be used if there are original materials. I mean, if there are primary materials like extracts from statutes, or extract from judgments, or extract from a treatise, it will not form part of a similarity. It will not be calculated for the purpose of examining whether the percentage of similarity is so much. When the observations, criticisms, or the secondary views of other scholars are paraphrased, and only their ideas are mentioned in a brief manner, and it is duly acknowledged, and their keywords are quoted with the quotation marks, then you will be free from allegation of plagiarism. Otherwise, you will be subject to plagiarism. So, in the calculation of this also, similarity, due consideration will be there about the use of the existing knowledge system, because no knowledge is new. It's developed on the basis of the past knowledge. That's when past publications are relied upon. If they are duly acknowledged, then it does not amount to plagiarism. But the percentage of taking of that information in the body of your writing, that is limited, and that is confined. See, insofar as citations in footnotes, actually, that will also be excluded from the calculation of a similarity. After excluding all these kinds of things, similarity is calculated. Then, if the similarity is from a 0% to 10%, it is at the zero level. The similarity level is a zero level, and of course, this means that up to 10% you can make use of the secondary materials also. But as a researcher, please develop your habit of developing your original ideas, and minimize dependence upon other sources, and it shall be confined to less than percent as far as possible. See, if it is more than 10% and up to 40% similarity, then there will be caution upon the person. Uh, yes, there will be yes, such a student shall be asked to submit a revised script. If it is a 10% to 40%, then asking for a resubmission will be the outcome of that kind of situation. Of course, he is given an opportunity to resubmit, and such a resubmission shall take place within 6 months. And the next level, level 2, is similarities beyond 40% up to 60%. See, there he shall be debarred from submitting that report, but after 1 year, he may resubmit by avoiding plagiarism altogether. That is the responsibility. If the extent of a similarity is more than 60%, then such a student's registration shall be cancelled. If he has registered for a PhD, or if he has registered for a LLM and he is expected to submit a dissertation, his registration itself will be cancelled. These are the stringent requirements. See, if articles are published, now suppose it is not a case of a submission of research reports for the purpose of getting degrees, but public submission is for the purpose of publication. There again, on the basis of these similarities, penalties may be prescribed. There is a minor penalty up to 10%. Then he may be asked to withdraw manuscript if it is more than 10%. If it is more than 10%, the editor of the journal may ask him to withdraw the manuscript. That is the penalty. If it is at the second level, he shall be asked to withdraw the manuscript. Then he shall be denied right to one annual increment, and he shall not be allowed to be supervisor of a LLM or a PhD. Then in case of similarities above 60%, he may be denied 2 successive annual increments, and he shall not be allowed to act as a supervisor. See, even at the level of professors or university teachers, these regulations will be operating, and these penalties will be there. Further, in case of getting benefit on the basis of publication of a plagiarized book or plagiarized article, then the benefit that he had got, say he got a promotion or he got a new appointment, that itself may be cancelled. Thus, stringent measures are there, stringent punishments are there under this uh, uh, regulations relative to plagiarism, and how best the academic integrity is to be promoted. About that, the university, college, or the institution shall conduct various trainings, uh, programs, workshops, or seminars, so that dissemination of this knowledge relating to anti-plagiarism rules shall be uh, informing the minds of young researchers, so that they'll be uh, framing their mind to avoid all such acts of plagiarism. See, ethical principles and moral considerations that ought to operate in a legal research or a legal publication or in the whole task of uh, gaining knowledge shall be within the overall framework of developing one's originality. See, originality does not come from heaven on its own. Originality is to be developed by the researcher on the basis of asking questions, finding answers, on the basis of searching such answers in various publications, and honestly and sincerely examining different viewpoints and duly acknowledging those viewpoints and going beyond all those viewpoints uh, and developing his own viewpoint, which is based upon his continued rigorous academic exercise and thinking. That ought to be done. And originality is the aim. It ought to be the aim of a researcher. See, another thing is that as a researcher, he should have that moral commitment to be away from various types of biases. As a human being, he might have some subjective views. He might have some views of his own because of his alignment with a particular religion or caste, creed, or sex, or community, or region. Because of this, he may have some view of his own, but he should stand above all these views, and he should uh, perform his research activity in such a way that he is free from all those types of biases. That's very much essential. Value neutrality is something that is to be developed because uh, value judgments are sometimes influenced by some of the subjective views of the society. But uh, instead of committing oneself to for those specific value judgments, suppose the researcher stands above the value judgments and uh, he conducts his research in an objective manner, then of course uh, he will be in a that Archimedes zone of uh, objectivity where he is free from various types of bias. Value neutrality does not mean that he should be thinking independent of the primordial values upon which the whole society is built. For example, the society has accepted the constitutional values as primordial values, as superior values, because constitution reflects some of the paramount principles like justice, equality, liberty, fraternity, dignity, and commitment to democracy and other institutions like secularism, socialism, etc. And constitution elaborates these values in various provisions. That's when the superiormost document or superiormost legal norm of the society has a commitment to those values. Actually, value orientation in one's thinking becomes quite a logical, and it is natural, and it is appropriate also, because the researcher, while conducting research, will have to keep in mind the paramount worth of human rights, intrinsic value of social welfare, or the social importance of harmony, social harmony, or harmonious society. There's a value neutrality coupled with the value considerations of constitutional principles. These are to guide him, and ethical principles are important because there are so many moral questions which the researcher comes across in the course of his research. See, whether a particular type of practice like a kambala, is it a good or bad? From the angle of the rights of animals, is it appropriate? Whether cruelty to animals is appropriate in the name of some social uh, entertainment or social refreshment, whether jallikattu is appropriate. See, such moral questions may arise. Similarly, whether euthanasia, passive euthanasia, or say negative euthanasia, is it appropriate, or positive approach uh, relating to say life-saving drugs, how exactly it shall be executed. About all those things, moral principles are there, and one will be asking questions. See, the researcher should collect data from those people. Now, suppose about the problems relating to, say, divorce, the researcher conducts a research. Is it appropriate on his part to probe into the minor issues involved in a husband-wife relation, asking wife or asking husband about the things went wrong in their marital life, etc. Whether uh, right to privacy on the part of those individuals shall not be respected. Further, even if he gets data, suppose he gets data on the basis of his promise that the data collected will not be disclosed to anybody. Names of the persons will not be disclosed to anybody. Suppose he discloses that information subsequently, is it appropriate? Or he makes a tom-tom of these things in social media and so many other media, because of which their the inner aspects of their life, personal life, are becoming a part of public knowledge. Is it appropriate? See, as a researcher, he has to consider all these things. That is why ethical principles become quite important, because along with the uh, getting access to truth, using appropriate method of getting truth is also becoming important. See, it's sometimes said that when the means adopted for getting truth is unfair, then the taint of unfairness operates upon the element of truth that you are getting. Of course, American constitutional system or legal system might be shunning those types of evidences as a uh, rule of exclusionary evidence, evidence that is obtained through unlawful methods or in violation of human rights. shall be regarded as a totally unreliable, and they shall be simply rejected because they are as bad as fruits of a poisonous tree. A poisonous tree will be yielding only fruits of a poisonous types, and fruits of such a poisonous tree shall be simply excluded. In the same way, here also, don't go for such a poisonous substances or poisonous types of approaches, like intruding to the privacy of others, or giving a wrong publicity, or using a say data belonging to some other person as if it is his own. All those things. See, one should get academic credit on the basis of his own performance, his own academic ability, and his own academic strength, and shining on the basis of works of others is uh, a temporary gain, and in the long run, society will come to know about your fraudulent act, and not only your product, you will also be simply distrusted. That is why don't involve in any kind of acts of plagiarism. Of course, there's at all stages of one's research activity, one shall adhere to ethical principles, because knowledge is not simply for the sake of knowledge. Knowledge is also for the sake of welfare of the people, and it is also for the sake of better protection of human rights, and it is for the welfare of the society as a whole. With this, let me conclude. Thank you very much. If you have questions, I will try to answer.
And promoting responsible research practices. With these key takeaways in mind, I would like to invite questions and discussions on the topic research ethics. Participants, please, you can ask questions if any. No questions? So let us proceed with the vote of thanks. So, dear participants, as we conclude this insightful session on research ethics, I express our heartfelt gratitude to Professor Dr. P. Ishwar Bhatt sir for sharing his valuable expertise. Okay. Okay, so there is one question.
There is one question, whether research ethics can be violated for a greater good. See, greater good is something that does not justify any deviation from the ethical principles. See, what greater good can be contemplated when a researcher conducts research about the state of affairs of prostitutes, when he discloses the identity of prostitutes, or about so many other personal details relating to prostitutes. What greater good is there? Similarly, if for decades together, persons who are affected by such a uh, venereal diseases like syphilis were denied of a life-saving drug like a penicillin, just for the reason that about a traditional medicine, traditional treatment, the researcher wanted to conduct research. Is it appropriate? What greater good is there? See, about avoidance of a plagiarism, can there be a greater good than avoidance itself? See, it is essential that he should share the knowledge, and his own knowledge is based upon the information borrowed from others. Thus, there will be greater good in ensuring that the source of all such information are made known to the whole society. That is the greater good. And keeping the society, say, misinformed or suppressing the information, all these things are not for a greater good. Actually, all those are four important principles of ethics in research. There's a rule against malevolence, rule in favor of benevolence, rule of autonomy, and rule of justice. All these four principles are foundational principles, and hence research ought to be done in an appropriate way. Yes, there was one question, some interesting question. There's a yes. Now I do not have access to that one. Whether a corrupt practice for getting PhD, is it something that could be tolerated? No, never. See, on the basis of experience only, that UGC has come out with all these regulations. There's a research thesis that a person, a research student submits should be of his own. He cannot go for outsourcing to some other person to draft his thesis and out this, or asking some person to write, etc. All these are shameless, corrupt, and unethical practices, and that shall be totally eschewed. And as researchers, we should have least toleration about these types of deviations. Yes.
Yes, sir. I express that.
Can it be bought? See, whether PhD can be bought? No, no. As per law, as per ethics, no. But if any such practices are taking place, then it is totally unethical. It is against all standards of education, and of course, law ought to operate against perpetrators of such conduct. Okay. Why does it take certainly 4 to 5 years for PhD? See, minimum period of 3 years is generally what the universities prescribe. And when the concerned person is working in some institution, getting access to information in library, analysis, and other things, that becomes quite difficult. Further, when he conducts research in the field of pure science, engineering science, or physics, or say bioscience, it is on the basis of experimentation that he shall conduct research. And experimentation is a long process. Sometimes it depends upon the availability of facilities in laboratories. And if the facility is not available, he has to go to some other lab and get the work done. And of course, all this results in delay. There's a 4 years period or 5 years period is a reasonable period, and we cannot say that it should be shortened or of course hurry in such circumstances will be causing a deterioration in a standard as well. Okay. I think I have answered the major questions.
Yes, sir. Thank you, sir. I express our heartfelt gratitude to Professor Dr. P. Ishwabhat sir for sharing his valuable expertise on behalf of Vaikunta Baliga Law College and all the participants present. Thank you, sir.
Thank you.
I also extend our sincere thanks to Dr. Nirmala Kumari K. Madam, Director, Vaikunta Baliga Law College, Udupi. Thank you, Madam. Thank you. We also thank Dr. Raghunath K.S., Principal, Vaikunta Baliga Law College, for creating an environment conducive to learning. Thank you, sir. Our sincere thanks also extend to KILPAR, Bengaluru for their association and support, our participants for their active participation, and also to all the faculty members and students of Vaikunta Baliga College of Law. Thank you all. Once again, thank you, and we wish you all the best in your future endeavors. Thank you once again.
From my side, let me thank Vaikunta Baliga College of Law and also KILPAR for giving this wonderful opportunity of sharing my thoughts. Thank you.
Thank you, sir.
Thank you, sir.
Thank you very much, sir.
Thank you. Thank you.
How are you, sir?
Thank you.
ಹೇಗಿದ್ದೀರಿ ಸರ್?
ಚೆನ್ನಾಗಿದ್ದೇನೆ
ಸರ್
ನೋಡಿ, ಹೀಗೆ ಮೀಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಯ್ತು ನೋಡಿ.
ಹೌದು ಸರ್. ಸರ್ 9th and 10th ಮೈಸೂರಿಗೆ ಬರ್ತೀನಿ ಸರ್.